The next slide is, I see a lot with debt collection lawyers, and the reason why I put this in there is that this falsely claiming to be a lawyer takes up several different forms. Back in the 90s, one of the things that was prevalent in consumer collections by lawyers or collection law firms was an attorney's use of letterhead by massively generating letters to consumers, using their letterhead, giving the appearance to the consumer that now that their consumer debt is now before a lawyer, and using attorney letterhead. The court went through this interesting analysis, and the Avila versus Rubin case is an example that set out a very, very unique aspect to debt collection in the legal field, which is that the lawyer has to have some meaningful involvement in the case. Meaning that in these instances back in the mid-90s, mass-generated lawyer letterhead that had no lawyer involvement was deemed to be deceptive or misleading. So when a lawyer would sell their letterhead or maybe provide their letterhead on a mass-generated basis but absolutely have no idea or involvement in the case, courts have felt that that was misleading or deceptive in a way that to cause a violation of the FDCPA. So the case in the Seventh Circuit in Avila versus Rubin and other cases that are very similar created an action where they needed to evaluate the meaningful involvement of the attorney in the case. So therefore they decided, well, let's look at the volume of letters versus the involvement of the lawyer in the process. And if there was clear evidence to show that there was absolutely no involvement of the lawyer in the case, then it would be harassing. So the mass volume of attorney-generated letters had virtually stopped. So lawyers became more involved in the cases and handling it. So this mass-generated ideas or areas kind of dissipated for the moment. Let's go to another question regarding harassment that's from our questions. The question says, does the debtor bear the burden of proving harassment, and how is that burden met? Well, yes, they do. The burden of harassment, like in any civil case, is based on the preponderance of the evidence. They have to show it, and it's a jury question. Unfortunately, when you have consumers as jurors there, the standard, like in any civil action, is by the preponderance of the evidence, and it's a gut feeling. It's going to be whether or not the action was intending to harass or abuse, and it's going to be 6 jurors, federal jury or state jury, to determine whether or not that conduct would be considered harassment or abusing. I understand I'm a federal trial practice lawyer. I've defended collection agencies for 23 years. We do get a fair shake. However, understand that there is a stigma attached to debt collectors, which we'll talk about in the litigation section of this case. When you're picking a jury, you're going to have to do a very good job at making sure you get a great jury that's not going to be sympathetic to a consumer or adverse to a debt collector agency as to the tactics. I've had instances that were totally legitimate collection agencies that were collecting decedent debt that was occurred by estates. They were looking for estates. Juries don't like that. Judges don't like collection agencies collecting on decedent debt. Another example is collecting past due debt that's outside the statute of limitations. Regulatory agencies, consumer advocacy groups, judges do not like voluntary collections of debts that are past due, and the regulations have this. So I think when you're talking about harassment and those instances, it's going to be a gut check on that. The question is a kind of a follow-up, is it obtained through oral testimony, recordings, debtor's word against collector's word? All of the above. When you're talking about proof of harassment, one of the most important things that when we'll talk about as far as compliance, harassment can be deemed through different sources. You can expect that the consumer is going to get up there and say what the verbal phone call in their mind said, and it's admissible evidence. It's a statement of the consumer's own testimony as to what was said. When we're talking about recordings, very important, collection agencies through the modern age have adapted, as long as they comply with the state wiretapping laws, is audio recorded conversations call observance equipment to monitor and record the conversations between their collection representatives and the consumers. Very, very important. The misconceptions of a consumer as to what's being said is certainly great evidence to have a recording of the actual conversation. It could be great evidence to prove that an action didn't happen, but it also could be great evidence for the consumer if your collector actually called someone a name or was abusive or harassing on the telephone. We had a trial that we won in front of a jury in Orlando last September where it was a harassment case. We provided the audio recordings to the jury, played them flat out, where she accused the debt collector of saying that he was going to ruin her credit. The audio recordings did not bear that out, and we've got a defense verdict. So oral recordings or audio recordings are critically important to disprove a violation. Debtor's word versus a collector's, that's probably the worst case scenario that you have. The reason why is it's no secret in our industry, in the debt collection industry, that debt collectors' term limitations or work experience don't last very long. The statute of limitations for the FDCPA is 1 year. In Florida, our state statute is 2 years. So if a debt collector is no longer employed, you're not going to have rebuttable evidence if you don't have an audio recording if the collector is no longer there. It's hard to prove a negative from the collection notes that someone was not called a deadbeat or some other name on the phone if a debt collector it does not have the ability to do it. More practically speaking, even if the debt collector agent is there, how often are they going to remember the conversation that happened 8 months ago specifically that they did not say something? There's a loss of credibility. Yes, they may say, I didn't say that, but certainly the volume of calls lessens their credibility as to recalling what that specific conversation actually had. The next question is, does the FDCPA, does it violate the FDCPA to serve a debt collector with legal process, summons and complaint to collect a debt at his or her place of work, if served personally, if served upon the person's assistant or office manager? The Fair Debt Collection Practices Act was amended recently to exclude the summons and complaint as a communication under the FDCPA. So the mere act of serving someone a legal process, by definition under the FDCPA, is not a communication under the statute. Serving legal process through the process server and stuff like that more than likely would be exempt. I don't think it'd be harassing. But one of the things that you need to be careful of is, although that practice may not violate the FDCPA, so far the statute only holds that is exempt, meaning what's contained or what the process of the is exempt. Understand that the Fair Debt Collection Practices Act preempts the litigation privilege that lawyers enjoy in normal practice. So lawyers can be held liable under the FDCPA, including tactics taken in litigation, except for things contained in the summons and complaint. But if you're harassing or you're doing something, filing a lawsuit outside the statute of limitations or doing some other actions that are litigation, the FDCPA preempts the litigation privilege and you could be liable under the statute.